You have to know what your state's law here is, because we've taken this time to very painstakingly go through the 1986 ISO form. We've taken this time to explain the building blocks of an insurance policy, the foundation. And what you're going to see in this Charles Construction case is that the Ohio Supreme Court didn't do that. It said, this appeal concerns the general contractor CGL policy that is nearly identical. It was the ISO 1986 form commercial general liability policy. And it says, but the question we're dealing with today is, does that CGL policy issued to the general contractor, does it provide coverage for damage caused by a subcontractor's faulty work? That was the specific issue before the Ohio Supreme Court last year. They had built this performing arts center and hotel for visitors to the Ohio Northern University, and there was property damage after it was constructed. Some of the property damage was due to the subcontractor's defective, faulty work, and that's what the Ohio Supreme Court had to decide. Look at that first sentence in this next slide. And we agreed with our sister court in Kentucky that in the context of a CGL policy, inherent in the plain meaning of accident is the doctrine of fortuity. The Fortuity Principle is central to the notion of what constitutes insurance. And then it said, I have it in bold language there, italics, under the CGL policy's plain language, property damage caused by a subcontractor's faulty work does not meet the definition of an occurrence because faulty work is not fortuitous. So all that discussion we had, all those building blocks we talked about, the Ohio Supreme Court went the other way. It's saying that the faulty workmanship of the subcontractor doesn't even come within the insuring agreement of the ISO 1986 CGL policy. It doesn't even meet the grant of coverage. And you'll also remember I said at the outset, it's the insured's burden, the policyholder's burden, to prove that the property damage that is being claimed falls within the insuring agreement. Well, in Ohio, contractors, general counsel, insurance coverage, you have to know that Ohio bucks the trend, Buckeye State, bucks the trend, and it does not provide coverage for faulty workmanship under a commercial general liability policy, the 1986 ISO form.